Have you ever picked up a product, maybe a can of paint, and thought, hang on, is this the same brand as that other one I used? Or just, really similar? Well, sometimes those little moments of confusion, they actually spark massive landmark legal fights. Welcome to the deep dive. This is where we take complex stuff, boil it down, and give you the absolute essentials. Today, we're jumping into a really foundational legal case from South Africa, Plascon-Evans Paints Ltd. Versus Van Riebeeck Paints Proprietary Ltd.
Yeah, this case, it was decided by South Africa's highest court back in 1984. And it's about much more than just paint. It's a huge ruling. It totally changed how courts look at brand name disputes, and maybe even more importantly, it set a massive precedent for how courts deal with factual arguments just on paper. It's kind of a key to understanding bits of trademark law and legal procedure.
So our mission today is to really unpack this case for you. We'll dig into the main legal questions, what each side argued, how the court thought it through, the final decision, and, crucially, the impact it's had since. Even if you're not, deep into law, the ideas here should give you a real aha moment about protecting brands and how the legal system works. Okay, let's get into it, right? Let's set the scene. Who are the players in this paint-focused legal drama?
Well, on one side, you've got the appellant, Plascon-Evans Paints Ltd. Big company, paints and related stuff. And they owned a registered trademark, Micatex.
Micatex. Okay, so that was registered way back 1971 for things like paints, varnishes, specifically ones with mica in them. And Plascon-Evans used it for a particular kind of product, like texture coating.
Texture coating.
Yeah, think thick, durable paint, mostly for outside walls, good for covering up little imperfections. And their Micatex specifically had about 9% mica in it and also some marble.
And Plascon-Evans didn't just, whisper about Micatex. From mid-78 to mid-79, they went all out. Huge promotional campaign, spent over $300,000, which was serious money back then.
Absolutely, and it worked. Sales shot up and stayed up. This wasn't just paint, it was a valuable brand.
Okay, then on the other side, we have the respondent Van Riebeeck Paints, another paint company. Now, around October 1978, Plascon-Evans spots them selling a texture coating, but under the name Micatex.
Micatex, okay.
Plascon-Evans wasn't happy, they objected, and Van Riebeeck actually agreed to stop using Micatex.
So you'd think, problem solved.
You would, but no. Fast forward to April 1979, Plascon-Evans finds Van Riebeeck selling another texture coating. This time, it's called Mikacote.
Mikacote. So Micatex, then Mikacote.
Exactly. And often sold alongside Van Riebeeck's main house brand, Decro. Now, their Mikacote product also contained mica, around 8.7%, though it didn't have the marble like Micatex did.
Interesting. And where were these being sold?
That's actually a key point.
Yeah.
Hardware stores, chain stores, general dealers. So the buyers weren't just pro painters. It was, ordinary people, DIYers, maybe without any special paint knowledge. That broad customer base becomes really important later.
So Plascon-Evans is thinking, Mikacote sounds way too much like Micatex. They believed it infringed their trademark, and also that it was passing off, basically, fooling customers into thinking Mikacote was their Micatex.
Yeah, they felt Van Riebeeck was trying to ride on their brand's coattails.
So naturally, they took Van Riebeeck Paints to court. And that kicked off the whole legal journey that ended up in this landmark appeal.
So initially, the case went to the Cape Provincial Division, sort of a regional high court. And the judge there sided with Plascon-Evans, granted an interdict that's a court order to stop something.
So stop selling Mikacote.
Exactly, stop selling Mikacote. And even ordered the existing Mikacote stock to be handed over for destruction.
Wow, okay. So clear win for Plascon-Evans first round.
It looked that way.
Yeah.
But Van Riebeeck appealed. They went to the full bench of that same court, basically a panel of more judges. And this time, the appeal was allowed. The interdict was overturned.
Oh, okay. So the tables turned completely.
They did. So now Plascon-Evans is the one feeling hard done by. They had to get special permission to appeal again, this time to the very top court, the Supreme Court of South Africa's Appellate Division. And that's where this famous judgment delivered by Judge Corbett comes from.
Okay, but before we get into the paint names themselves, there's this procedural thing that came out of this case, right? Something huge.
Oh, yeah. It's almost more famous than the trademark part in some legal circles. It's called the Plascon-Evans Rule. And it tackles a really practical court problem. What do you do when there's a disagreement about the facts, but the case is being decided only on written documents, affidavits with no live witnesses?
Right, because normally you'd have cross-examination, people testifying.
Exactly. So the old rule is pretty much, if the person defending the case, the respondent, denies a key fact stated by the person bringing the case, the applicant, the court usually has to accept the respondent's version unless it's obviously unbelievable. Makes it tough for the applicant.
Seems like a roadblock, but Plascon-Evans changed that.
It clarified it significantly. The court said, yes, the general rule holds, but it's not absolute. Just because the respondent denies something doesn't automatically mean there's a real, genuine dispute of fact.
Ah, so you can't just deny everything and expect the court to buy it.
Precisely. The court said if the applicant's story is inherently believable, or if the respondent's denials are just so far-fetched or clearly untenable, just totally unbelievable on the face of it.
Then the court can reject those denials.
Yes. The court can reject them merely on the papers and proceed based on the applicant's version of the facts without needing a full trial with oral evidence.
That's huge. It means courts aren't just stuck with the denial if it clearly smells fishy. It's about credibility, even on paper.
Exactly. It prevents people from just blocking a case with flimsy denials. In the Plascon-Evans case itself, the court still had to apply the rule carefully, but the clarification became this massive legal principle used in countless cases afterwards. It saves time, saves money, and helps get to the truth faster in these paper-based applications.
Okay, so that's the super important procedural takeaway. Now back to the paint. What was the first actual trademark issue the court had to decide?
Right. The first big question was, Van Riebeeck using the name Mikacote, was that actually used as a trademark according to the law?
Why was that even a question?
Well, the Trademarks Act, Section 44(1)A, talks about infringement being the unauthorized use as a trademark. Van Riebeeck's lawyers tried this argument. They said Micacote wasn't a brand name, it was just a product name, therefore not used as a trademark.
Okay, product name versus brand name. Is that a real legal distinction here?
The court basically said, that distinction isn't immediately obvious. They looked at the facts. Van Riebeeck's product was sold as Mikacote. Customers asking for Micatex were sometimes offered Mikacote. And the kicker,
What was it?
Van Riebeeck had actually applied to register Mikacote as their own trademark.
Oh, well, that kind of blows their argument out of the water, doesn't it?
It pretty much did. The court looked at all that and said, yeah, we're satisfied that respondent's use of the word Mikacote was used as a trademark. So, issue 1, check. In favor of Plascon-Evans.
Okay, so Mikacote was being used as a trademark. That leads straight to the main event, right? The big question was Mikacote so similar to Micatex that it was likely to confuse or deceive people?
Exactly. This is the heart of the infringement claim. And the burden of proof, the onus, was on Plascon-Evans. They had to show there was a probability, a real likelihood of confusion or deception.
Not just a possibility, but a probability.
Yes, among a substantial number of people who might buy these products, not necessarily everyone, but a significant chunk. And confusion could mean thinking the products are the same or thinking they come from the same company or that there's some kind of business connection.
So how does a court figure that out? How do you compare Micatex and Micacote legally?
The court laid out some key principles. You look at the marks based on their sense, their sound, and how they look visually. You have to imagine the average customer.
The DIYer we mentioned earlier.
Yep. Someone with average intelligence, having proper eyesight, and buying with ordinary caution. Crucially, you don't just put the marks side by side. You have to consider them separately. Why? Because the average buyer might see one product one week and the other the next week.
And they only have a hazy memory of the first one.
Exactly. An imperfect recollection, as the court put it. People often remember marks by the general impression, or maybe one significant or striking feature, not every single letter.
That makes sense. You remember the gist of a name.
Right. The court also mentioned notional use, thinking about how the marks could be used fairly. But here, because the products were the same type, they mainly focused on the actual way both names are being used.
So applying that to Micatex and Micacote.
The similarities jump out. Both 3 syllables, both start with Mica or Mica, sounds identical. That Mica bit is clearly dominant. It's the first thing you hear, the part you stress.
And the endings, tex and coat.
Different, yes, but as you pointed out, they both kind of sound like they relate to texture coating, the product type. It reinforces the association.
So the court pictured that average buyer.
Yeah. Maybe someone not skilled in paint with that imperfect memory, just remembering Mica something or that paint starting with Mica. They walk into a hardware store, see Mikacote, and could easily think, that's the stuff I was looking for.
Or at least wonder if it's a new version from the same company.
Precisely. The court felt this confusion or deception could happen on a substantial scale, Or, at the very least, people would be confused about whether there was a material connection between the two brands.
So the conclusion on confusion was,
Plascon-Evans had successfully proven infringement. Checkmark for issue 2 as well.
okay, 2 down. But Van Riebeeck had one last defense, didn't they? Something about description?
Yes, they tried Section 46B of the Act. This section basically says owning a trademark doesn't stop someone else from using a bona fide description of the character or quality of his goods.
Bona fide meaning?
In good faith. Honest. So Van Riebeeck argued Mikacote was just an honest description because their paint contained mica. They were saying, we're just describing an ingredient.
That sounds plausible on the surface. How did the court handle that? What does bona fide description really mean here?
The court looked at the purpose of that section. It's there to protect ordinary language, to let traders describe their goods fairly, using common words, especially if rivals couldn't easily describe similar things without those words. It's not meant to let someone hijack another company's well-known, maybe slightly fancy word.
Like Micatex.
Exactly. Especially not just to piggyback on the goodwill Plascon-Evans had built up. It boils down to genuine intent versus having an ulterior object, like trying to confuse customers and benefit from the Micatex reputation.
So is Mikacote seen as a genuine description?
The court said no. Firstly, mica wasn't really a common descriptive term in the paint trade back then, not like Plascon-Evans had used it. Micatex had built up significant goodwill. And while mica was an ingredient, Van Riebeeck could have easily told people their paint contained mica in other ways.
How so?
Simple ways, like just listing it in the ingredients or saying contains mica on the label, without in any way infringing the Micatex mark.
But instead, they chose Micacote.
Right. They chose to weave mica, spelled Mica, into a name that sounded very similar to Micatex. The court called Mikacote, not a word in ordinary use, more of a fancy name.
So not really descriptive to the average person?
Not necessarily. An uninitiated person wouldn't automatically know it meant contains mica. The court decided Van Riebeeck used it as a trade name, not a fair description. And looking at everything, the similarity, the previous use of Micatex, the court felt it pointed to that ulterior object, trying to deceive or confuse and cash in on Micatex's goodwill.
So the bona fide description defense failed completely.
Completely failed. That was the final issue decided against Van Riebeeck.
So wrapping it all up, the Supreme Court found for Plascon-Evans on all counts. What was the final outcome?
The appeal by Plascon-Evans was allowed, with costs. The full bench's decision was overturned, and the original trial judge's order was effectively put back in place. Van Riebeeck was infringing the Micatex trademark and had to stop.
It's such a clear story when you lay it out, but the impact, the legacy, goes way beyond just Micatex and Mikacote, doesn't it?
Absolutely. As a trademark case, Plascon-Evans really cemented key ideas in South African law, especially how you assess confusion, focusing on that average customer with their imperfect recollection. That's still vital today.
But then there's the other legacy.
The procedural one.
Yeah.
The Plascon-Evans rule about dealing with factual disputes on paper. That's probably its most cited legacy, used constantly in all sorts of cases way beyond intellectual property. It gave courts a practical tool to deal with questionable denials efficiently.
So it's a landmark case on two fronts, really. Trademark substance and legal procedure.
Definitely. It shows how the law protects brands, how fine the line can be between similar names, and the importance of genuine competition versus trying to confuse the market.
And for you, listening, it's a perfect example of how these legal principles aren't just abstract ideas. They shape business decisions, marketing strategies, and how courts actually operate day to day. Every brand name has a context and often a lot of legal thought behind protecting it. So we've navigated Micatex versus Mikacote, the tests for trademark infringement, and that crucial Plascon-Evans rule. It really highlights the law's role in guarding brands and ensuring fair play in the marketplace.
Yeah, understanding cases like this gives you a real window into how the legal system works, how principles get applied to messy, real-world business fights. It makes you think more critically about brands, names, and how we as consumers perceive them.
Well, thank you for joining us on this deep dive. We hope you feel well informed about this key case and maybe have a bit more appreciation for the complexities behind brand protection.
And it leaves you wondering, doesn't it? In today's world, with AI churning out endless brand names, how will courts apply this idea of imperfect recollection? What new challenges will pop up for making sure marks are truly distinct? Definitely something to think about.
Indeed. Until next time, keep exploring, keep questioning, and keep diving deep into the knowledge that shapes our world.